So good afternoon, everybody. Thank you so much for joining us today at ULINK at the law school. This is our third effort to bring scholars from across the university together around issues of social equity, race, and anti-Black racism. I'm extraordinarily proud of the diversity of scholarship in this area within the School of Law. Very grateful to Lily Levy, the research dean, for assembling an incredible group of legal scholars to share the work that they're doing to advance equity. So thank you very much. And I am looking forward to what I think is going to be a very compelling and critical conversation.
Thank you, Dr. Kobetz. Good afternoon, everyone. What a great event. Welcome to ULINK at Miami Law, faculty projects addressing race, diversity, and equity. It's truly wonderful to see how many of us at the law school are working on issues that the Vice Provost for Research and Scholarship, Erin Kobetz, has identified as the theme of the ULINK events this year, and that 12 distinguished members of our Miami Law faculty will share their work in this area. The law school is thrilled to be a part of a university with deep commitments to diversity, inclusion, and racial justice, and I thank Vice Provost Kobetz and her team and appreciate this opportunity to have us share our work at Miami Law with the whole university community. I also, by the way, thank our Vice Dean, Lily Levy, for putting this event together. So thank you, Lily, very, very much. As we are 1U, the invitation to share our work with the rest of our colleagues and the UM community is a welcome opportunity to build bonds and enhance our impacts in response to important challenges facing both universities and society as a whole today. So welcome, everyone. Thanks for joining us. And Lily, please take it away.
Thank you very much, Tony, and thank you very much, Erin, as well. Good afternoon, everybody. Welcome. I'm Lily Levy, and I have the honor of moderating this ULINK showcase today, featuring the Miami Law, some large part of the Miami Law faculty. I'm going to take just a few moments to introduce the law school's participants in alphabetical order. The shortness of time, of course, means that I'm just going to scratch the surface of their accomplishments. More about them can be found on the Miami Law website, and I commend you to that website to go and find out about all the amazing things that they do. Before I get to that introduction of the panelists, though, I would be remiss if I didn't thank Eva Olivares and Lauren Bailey and their teams for dealing with all aspects of communications regarding this event. None of you would be here without them, and so thank you. Also, I am indebted to my wonderful colleague Hakeem Lakhdar and Alina Hernandez for all of their work for this event, so thank you very much. So without further ado, on to the introductions. My former Associate Dean, Donna Coker, and friend, of course, is Professor of Law and Dean's Distinguished Scholar at Miami Law. Her scholarship focuses on criminal law, gender, and race inequality. She's a nationally recognized expert in intimate partner violence law and policy, exploring the connections between economic vulnerability and intimate partner violence, restorative justice responses thereto, and the intersections of gender and race subordination in criminal law more generally. Next is my colleague, Charlton Copeland, Professor of Law and Dean's Distinguished Scholar. Professor Copeland teaches constitutional law, administrative law, and federal courts. His research interests include the institutional impacts of polarization in American politics. A recent recipient of the prestigious Clyde Ferguson Award from the Association of American Law Schools, a prior winner of our own Richard Hausler Golden Apple Award, and the author of much award-winning scholarship, Professor Copeland contributes outstandingly to the law school on every front. I'm also thrilled to introduce Xavier Cortada, Professor of Practice in the Department of Art and Art History, and also, by the way, my beloved former student at the law school. We have to claim you here, X. The multi-talented Professor Cortada is part of our ULINK team on the move, climate migration and retreat in South Florida, the Caribbean, and beyond. using arts elasticity to work across disciplines to engage the community in addressing a future with rising seas. Over the past 3 decades, Professor Cortada has created art across 6 continents, including more than 150 public artworks and dozens of collaborative murals and socially engaged projects intended to generate awareness and action in connection with issues of global climate change and social justice. I then come to former Vice Dean and now my friend and faculty colleague, Patrick Gudridge, Professor of Law and Dean's Distinguished Scholar at Miami Law. Riveting theorist and storyteller both, Professor Gudridge has taught constitutional law, federal courts, and a variety of other courses of the law school since 1977. His influential writings carry titles such as The Persistence of Classical Style, and The Rule of Law and Constitutional Law Within Formal Realism. Yet another stellar colleague, Elizabeth Iglesias, Lisa, is a professor of law who teaches constitutional law, law and political economy, and international criminal law. She is a co-founder of Latina and Latino Critical Legal Theory, Inc., aka LatCrit, an important movement in legal theory since the 1980s. In addition to leadership roles in the profession, Professor Iglesias is also currently completing a PhD in philosophy, specializing in political philosophy and ontology in the continental tradition. Next, let me introduce my colleague, Shara Kobetz-Peltz, Professor of Legal Writing and Lecturer in Law at Miami Law. I am proud to say that Professor Peltz is a Magna graduate of our own law school and has been teaching our students best practices in legal communication since 2006. A former assistant public defender with Miami-Dade County, Professor Peltz and her students have also undertaken an impressive pro bono project to teach legal writing, persuasion, and advocacy to incarcerated persons at the Dade Correctional Institution. Truly a labor of love. Our much beloved Marnie Lennon is the Assistant Dean for Public Interest and Pro Bono and a lecturer in law at Miami Law. She is the founder and director of the Hope Public Interest Resource Center and has worked at Miami Law for 26 years. And she also is a wonderful former student and friend of mine. She teaches alternative dispute resolution, ADR design systems, mediation, and social justice lawyering. She has served in numerous leadership roles for the Student Services section and the Pro Bono section of the Association of American Law Schools. My indefatigable friend and colleague, Jonelle Newman, is professor of law and director of our celebrated Health Rights Clinic. In addition to her clinic responsibilities, Professor Newman teaches professional responsibility and civil procedure. The recipient of notable awards from both the ABA and the Florida Bar Foundation, Professor Newman now somehow finds more than 24 hours in the day in order to serve as the first vice chair of the Faculty Senate at the University of Miami, and extraordinarily well. Next is my fabulous colleague, Rebecca Sharpless, professor of law and director of our very impactful immigration clinic. In addition to her work with clinic students, Professor Sharpless teaches immigration law. Her work with the clinic inspires widely read scholarship focusing on the intersection of immigration and criminal law. Professor Sharpless is also active in leadership in her field, having served as the president of the South Florida chapter of the American Immigration Lawyers Association, and also as National Lawyers Guild National Immigration Project board member over many years. My much admired colleague, Keely Stewart, is Associate Dean for Experiential Learning, Professor of Law, and co-director of our widely respected Children and Youth Law Clinic. In her clinic work, Dean Stewart supervises law students in representing children in the foster care system. She also teaches courses on family and juvenile law and legal practice. Her scholarship often is in the areas of child welfare, children's rights, and clinical legal education. and effectively marries empirical methods and legal theory and is often interdisciplinary. Her research and law reform advocacy focus on the extraordinarily important project of improving outcomes for vulnerable children. Let me next introduce Melissa Swain, my colleague, who is a very effective associate director of our health rights clinic and a lecturer in law. A former public benefits staff attorney at Florida Immigrant Advocacy Center in Miami, who now works very closely with Professor Newman in the Health Rights Clinic. I'm happy to say that Professor Swain also is one of our own accomplished graduates. Her work with the clinic has also generated important law review scholarship. And finally, last but far from least, is William Wyden, who is a professor of law at Miami Law. Professor Wyden is an elected member of the American Law Institute and a former partner at Cravath, Swain, and Moore, bringing years of sophisticated legal practice to the classroom. He teaches contracts, commercial law, and other business subjects. His scholarship includes both complex work in the business area and recent publications on social justice topics. That's the crew, everybody. Without further ado, I would ask them to speak in alphabetical order and take 7 minutes to discuss recent work reflecting the themes of this year's ULINK showcases. We'll have time for Q&A after the presentations are done, and I will keep the queue. Please feel free to indicate in the chat that you have questions or use the Zoom hand raise function to alert me. And that's what I've got. Why don't you lead us off, Donna? Perfect.
All right. I'm just so happy to have this conversation, and I'm always humbled when I'm on a panel with my colleagues. So I'm really grateful for my colleagues and grateful to be here. And thank you, Dean Levy, for that introduction. So my work examines, in part examines the harms of the carceral system, particularly examining it through the lens of the intersections of gender and race and class, and somewhat gender identity and sexual orientation. And then in addition to that, through a community lens. So what I mean by that is understanding, for example, the impact of hyper surveillance and hyper controlling policing in minoritized communities. So I think most of us are familiar with the incredible growth of the carceral system, and that occurred, I think it's important to note, at the same time that the always too underdeveloped U.S. welfare system was completely hollowed out. And that at the same time, we see this growth in the use of criminal instrumentalities and ideologies to respond to all sorts of behavior, all sorts of social problems, and also as a means of addressing issues in child welfare, for example, immigration, for example. So we get crimmigration, which I'm sure Becky is going to talk about. So the aspect of this work that I want to talk about today is what I call reimagining the movement to gender violence. This project began really in 2014 with a conference that I helped to organize that was held here at UM called Converge. We brought together more than 200 activists, practitioners, activists, policymakers, scholars, and students to think about a way to address gender violence that was less crime-centered and that was more focused on structural inequalities that create and maintain violence. This organization is intentionally anti-racist in its practices and perspectives as well. The reimagining movement then encompasses support for policies that move away from crime-centered approaches and address racial and economic justice. So interestingly, importantly, in the last 10 years, I think, we've seen a significant movement, a significant change within what I'm going to call, for lack of a better term, the mainstream anti-violence feminist organizations. We're in now what some have called a feminist reckoning, as critiques of, quote, carceral feminism become more salient, ever more salient, with the backdrop of police killings of unarmed Black men and women and the large-scale mobilization prompted by Black Lives Matter. We now have several state coalitions, for example, coalitions against domestic violence and sexual assault, who have specifically adopted anti-carceral positions, refusing to support any additional criminal legislation in their field. We have a huge number of coalitions that signed on to a letter called A Moment of Reckoning, in which they addressed the feminist collaboration in the growth of the carceral state. So my work then in this field is I'm talking about 6 things quickly. One is to support these anti-violence organizations that are making this move. And so I've done that through webinars, through collaboration with the National Clearinghouse for the Defense of Battered Women that works with system-involved women, to do training on mass incarceration and also on restorative justice responses to intimate partner violence and sexual harm, white papers and expert testimony to help state coalitions oppose criminalizing legislation. Of course, my scholarship also addresses this significantly, most recently looking at comparative analysis of the use of restorative justice to respond to intimate partner violence. I'm also creating a website with the assistance of a UN postdoctoral student, Ajane Billingsley, with whom I've collaborated several times. We have 8 edited interviews with leading figures in this movement. And that's right now a part of Media for Change, a nonprofit organized by Professor Sanjeev Chatterjee in the communications department, but soon will be an independent website. That website will be a hub for all the various strains of this movement, including understanding the relationship of economic justice to the creation of crime, looking at police racially biased actions, and particularly looking at actions against Black women, looking at these changes in the mainstream movement, connecting to restorative justice responses as well, and 2 more. So I'm also part of a group that's writing a gender violence textbook. And the gender violence textbook really is aimed at the other important aspect of this work for me. And that is really to train the new generation of lawyers who are doing work in gender violence, to bring a critical perspective to the criminal focus that has been with us now for over 20 years. And to help them think more expansively about what that work means, to think about that work through, for example, economic justice and a racial justice lens. And finally, I teach social justice lawyering, and I also teach gender violence and social justice, in which we explore these perspectives as well. And I create internships for students to do criminal justice policy reform. How'd I do in the 7 minutes?
Wow. Oh my God, this is great. You've made up for my long introduction. Thank you very much, Donna.
Sure. Thank you.
Next up, I have X.
It's a pleasure to be here, Professor. I'm not in your class, but I'm as nervous as I was back in BA in the day.
You were never nervous.
Okay, well, I'm having a good time here with you. Anyway, let me go ahead and share my PowerPoint. So it's a pleasure. Dr. Levy, Professor Levy, everyone can hear me, right? We're good? I can't hear you, but I know that you're saying yes.
Yes.
Right,
yes.
so I am part of a ULINK team that really wants us to understand the existential crisis that we are in. And I am honored to be part of a team that involves 3 of my colleagues, obviously Professor Ali at the School of Law, as well as Professor Catherine Mack over at the Rosenstiel School, a climate scientist, and Ian Wright, who is a faculty member in our School of Business. And together, we are trying to understand what is going to befall Miami and how Miami is going to react so that we can plan for that future. And it's a future that's really important if you care about social justice, because the truth is there are 2 Miamis and they are splintering more and more each day. Our project has 3 main objectives. I was asked by Professor Ali to focus a little bit on the 3rd objective. So it's going to be a little bit different of a presentation than the one that we had before. In other words, not a purely legal presentation. So I'm going to talk about the power of art to engage others and to work across disciplines in order to problem solve. And I normally do that by engaging people in things that are about experiential learning. To the left are the FP&L bills, rates that keep on rising as airplanes going up and up to the sky. On the other, we're addressing environmental degradation. On the right, we have people putting their property values as little boats creating an underwater flotilla. All of these, to the left is the opening of an art exhibit where Antarctica landed. Climate change doesn't care about your timeline, it's working on its. So it creates disruption and we have to anticipate and prepare for it. But by engaging in experiential activities, we are able to work with communities so that they understand the trouble we're in. By piquing curiosity, we learn together and work together to address problems. Obviously, our carbon footprint is creating a blanket across our atmosphere that is warming our seas. That has a feedback effect that creates stronger, wetter, and slower hurricanes, Maria, Harvey, Dorian. These will impact communities and disproportionately impact communities that don't have the ability to get on a plane or leave town or the resources to survive a post-hurricane event. But our problem is bigger than that. This is Miami, not present Miami, but future Miami. That Antarctic glacier is coming here. And everyone is concerned about 20-foot walls. Everyone is concerned about what's going to happen. How do we address the infrastructure? How do we deal with the core of our city? But Miami isn't just a city with one coastline. Miami has two coastlines. On the east, we have the Everglades, and on the west, we have in the east, we have the Atlantic, and on the west, we have the Everglades. And few understand that the vulnerability of a Sweetwater, of a Florida City, of a Kendall, of a Hialeah is dramatically higher than that of a Key Biscayne or a Miami Beach that has the tax base density and resources that can adapt immediately. But there's also a third coastline in Miami, and that is the water beneath our feet. Our aquifer, our freshwater aquifer, what gives us water for agriculture, drinking water, and the plants outside our homes, are also subject to the impact of sea level rise, even if you're miles inland. Why? Saltwater intrusion into the aquifer salinates the fresh drinking water. At 7 feet, that is what these glaciers will make Miami look like. And the issue is that folks that are in coastal areas have the capacity and ability to survive that crisis in a way that folks in the Western areas don't. But importantly, there's also another grouping of people. It's not just the low-lying residents on the western part of Miami. It's also, or the low-lying, low-income residents who don't have the resources to move. It's also the low-income residents in the elevated portions of Miami that will suffer from climate gentrification. Now, our project at ULINK focuses on climate migration, what is happening, not just in Miami, but also the impact the Caribbean basin will have on Miami. Every revolution, every external effect in our Caribbean basin impacts Miami because we are literally part of it. So that same way that a Haitian earthquake or a Cuban revolution or a drug war in Colombia has an impact on our immigration, so too will the impacts of climate have on our Caribbean basin and on Miami's future. And we are researching and just got a paper as our team, our first year team got a paper accepted on looking at social practices, art as a way of helping us understand what that future may look like. Piece we created was Pathways of the Cursed. And there is a certain resolver, or we will problem solve gene inside many of these Caribbean nations and neighbors that may actually be of help to us as we move forward. So we do know that those with wealth, those with second and third homes will be better off than those who aren't. And we're trying to figure out what policies we can make so that we can help with the future. And what I do as part of that team is make the invisible visible. I try to help us understand what that future will look like. And one way I do it is by using technology. There's an app where we invite members of the community to put their property values, and that tells you what the elevation of your property is. Then we ask you to use a marker, one of several markers that we've created, and put it in your front lawn, so that instead of having a political sign or having a for sale sign, you're having a sign that has everyone understand that you're in the same ground, that you face the same vulnerability. And our hope is that catalyzes the kind of response, the weirdness of this sign in your front lawn, catalyze the kind of response that's going to make you work and interact with your neighbor. We also have a way of having people paint their own signs so that they too can engage in those conversations. We've created a series of installations where people themselves mark the topography. One thing we don't understand in Miami is that the farther west you are doesn't necessarily mean the better off you are from the calamity of rising seas. Unlike a hurricane, the water will rise, but it will not recede. So what we did is we marked an entire street east to west at its intersections every 5 blocks, and showed that there was low elevation by the coast, but as you moved up into higher ground, clearly the elevation, the coastal ridge was there, but then west of that ridge, you're going towards the Everglades. So people west of the ridge are as vulnerable as those on the other side, especially if a storm surge event tops that ridge. 3 feet more to our sea level out in the bay would have made Hurricane Andrew top that ridge and go all the way to the Everglades. So we are indeed facing an existential crisis in this community, and through our installations, through our community meetings, and especially through our Underwater Homeowners Association, we try to engage others in the problem solving so that they are the protagonists, they are the change agents, and hopefully we'll build a cadre of engaged citizens who are more science literate, more empathetic, and better poised to be able to tackle the problems to come. We meet on a regular basis. Almost every meeting has a different faculty member from our university convening a conversation. We've been on Zoom for a full year now. And this is part of the work we do. There are other engaged projects and practices that can lengthen your care horizon. One of the biggest problems we have is that Miamians either ignore the problem, we do everything we can during a hurricane, but when it comes time to focus on the problem that will not go away, sea level rise, we put our heads in the sand. Similarly, there are many who say, I'll be dead by then. So I create other projects that help us lengthen our care horizon.
Well, this is very important work, X. I don't know what happened there, but thank you, X. And maybe during Q&A, you can give us a little bit more of a taste
Sure.
of the various other projects. I think now what I'd like to do is move to my colleague, Charlton Copeland, to ask him to address the kind of work that he's doing.
Good afternoon. Thank you for organizing this, Lily and Hakeem. I appreciate the opportunity to talk about this. I'm not a part of a ULINK cohort, but just responded to Lily's request. The title of my project at the moment is called "In Defense of a White Man's Bureaucracy." It's a project that is driven by an interest in the deployment of the administrative state over the last 4 years in ways and in areas that I think comport with descriptions of the Trump administration as a white protectionist administration, not and tries to think about that as a new form of American racial policy that both responds to shifting and changing demographics in American society, but also responds to an increasing sense of vulnerability that is held by white Americans with respect to their vulnerability to discrimination and their need for government protection in many respects. And so I want to talk a little bit about the areas of action by the Trump administration that have led me to think about this. And they're fairly broad, and I don't know that I'll take them all up, but in the context of policing, we saw the Department of Justice reverse consent decrees in an effort to reform many police departments. We saw also a reversal of the ban on the transfer of military equipment that many have argued is at least part of the problem with respect to the nature of policing in marginalized communities. We saw a downsizing of the special litigation section that is responsible for police litigation within the Civil Rights Division of the Justice Department by the Trump administration. In the context of civil rights enforcement, we saw a reversal of Equal Employment Opportunity Commission pay rules that required employers to categorize pay on the basis of sex, race, and ethnicity. We saw an elimination of the Consumer Financial Protection Bureau's power to enforce anti-discrimination provisions in lending. We saw in the FBI a reduced investment in and investigations of white supremacist groups. We saw in the context of social welfare increasing efforts to impose additional work requirements in Medicaid and SNAP programs, both legislatively, but primarily bureaucratically. In addition to those efforts, we saw efforts to carve out and protect areas that were disproportionately white and disproportionately rural. We saw additional executive orders that were engineered or by the executive through the use of executive orders. In the context of housing, we saw the Justice Department stop FHA or Fair Housing Act disparate impact suits. We saw a reversal of the HUD rule on disparate impact. In the context of immigration, we saw the administrative state deployed in various ways. The variety of bases with respect to immigration are almost sort of too many to name in terms of the time limit that I have here, but increasingly, right, the rescission of DACA and the administrative expansion of authority to remove persons from the United States without very much in the way of procedural protections were expanded bureaucratically. And so these and other initiatives undertaken by the Trump administration via the administrative state call for some serious engagement with the nature of executive power and the changing nature of executive power. Historically, we've understood or thought we understood the presidency to be an institution that represented a certain kind of middle ground in American politics, right? That the president would represent, in part because of the Electoral College, in part because the president is the sort of singular elected official elected by all Americans, that the presidency would itself be, at least in some respects, a kind of moderating force, at least from a sort of ideological perspective, even if, according to some social scientists, we understand the president as disruptive. But the president is this conception of the presidency, I think, is not right, at least with respect to the increasing ways in which the presidency has allowed for a certain kind of polarization. And we saw that not simply within the context of the Trump administration, but even in the second Bush administration and in the Obama administration. And so this project is an attempt to try to think about an increasingly polarized public, an increasingly polarized executive, and the ways in which the administrative state can be deployed in ways that, at least in this particular presidency, underwrite what I take to be a new and developing racial agenda of white protectionism in America and American politics. Thanks. Thanks so much.
Thank you, Charlton. I look forward to reading the paper. Next, I have Pat Gudridge.
Yes, I'm unmuted. Remarkable.
Yes, you are unmuted.
I named this talk, which I've written out so that I could have a chance of staying within 7 minutes. I named this talk "Lynchings Considered as Constitutional Instruments Considered as Works of Art." Before I get immediately to that topic, I thought it important to try to figure out if I have a method or a set of assumptions that explain why it is that I'm doing, not just here, but in other work that I do. And for interdisciplinary efforts of various kinds, and mine is out at the edge of that, this might capture something. I start with the notion of law as it is found in law schools. Law figures in this setting, frequently anyway, as first of all a heap, a pile of materials needed to be sorted in some sufficiently ordered way. An almost agnostic order, we might wish, boring or trivial, in advance somehow of whatever we will do with what we find, discernible in what we find, but not the immediate or main point, discernible as generic maybe, noticed and passed over at once, a substrate of sorts. We might begin, for example, noticing institutions, forms, and norms. There ought to be readily evident combinations of these three initially weakly defined whatevers, combinations to be taken apart and rebuilt, in the process perhaps involving us in thinking harder and more elaborately about what we have. But maybe these banalities remain so across transformations, not much more than invariant markers, uninteresting rigid designators, repetitions or stutters, as it were, seemingly, we sense rather quickly, leading pretty close to nowhere else. We might search outside instead, hope to escape banality or bring to banality modes of thought already well developed, different enough to sharpen our scrutiny, to show off what we hadn't noticed in our preliminary sorts. Thus, law and law schools open up to religion and history, economics and sociology, philosophy and political science, anthropology and literary consciousness, psychology and medicine, engineering and statistics, linguistics and computation, and media awarenesses, and much more. In prospect, many potentially ruling norms and forms and institutions, maybe. Now each asserting its own sharpness, its own differentiating elements, its own independence. Just a new heap? Except way harder to traverse. We tend to pick neighborhoods, try to come to terms with disciplines closest at hand somehow, work out accommodations as well as we can, and they can leave any account of overall unresolved. Samuel Beckett's problem, maybe. Our good place? Another way. Maybe law and our other accumulating preoccupations merge or in any event elaborate in response to perceived crises, horrors at hand or in prospect, something more like terror, precisely not banality, ordinary emergency. John Rawls on the beach in the Pacific in World War II. One damned island after another, they'd say back then. Ubiquitous combat, veils of ignorance over and over, frightening originality. Around the same time, Carl Schmitt in Berlin, lecturing in praise of Spinoza, trying to do so and still survive by randomly scattering anti-Semitic catchphrases, chaff confusing radar. Are Rawls and Schmitt in these maybe too near to fictional, not too accurately described settings, our principal guides in thinking about law, caught between inarticulation and corruption? Rawls and Schmitt both survived, we know. Welcome to American law. My own work right now treats horror as constitutive within American constitutional law. I focus, there are obviously quite a few other alternatives, on the installation of white supremacy as a counter-constitution, in the beginning through fierce insurgent combat, terrorizing and demoralizing and largely defeating ongoing Reconstruction, but maybe more importantly later on through development of a new constitutional instrument alternative to law, law having been taken over by the opposing and opposed 14th Amendment, lynchings reconceived, not ad hoc rough justice, now becoming a culture of human sacrifice in which numerous grotesque tortures and killings of individual African Americans are staged as expressions of the premises of white supremacy and as repudiation of the opposed assumptions of the 14th Amendment legality. Works of art, pledges of allegiance, as it were, constitutive horror. This regime is in hand roughly for half a century. We would like to think that constitutional lynchings disappear, sort of. If not in flashback, of course, Charlottesville, the ending of Spike Lee's movie, January 6th, not even in flashback, we may think, if we think about current police killing practices. If we want to mark a fading away, we know who some of the heroes are. Countercultural warriors, Ida Wells, W.B. Du Bois, Walter White, The Crisis, the NAACP magazine, the NAACP itself in this period, the still astonishing counter artistry of the sit-in burst in the early 1960s and the aftermath through Birmingham and beyond. Notably, none of these actors give pride of place to law work in any immediate sense. But there was also Scipio Africanus Jones and his sidekick, Oliver Wendell Holmes. Jones is not well known. Born into slavery, he became a quite active Arkansas lawyer. In the wake of the Elaine massacre and the death of hundreds of African Americans, local white leaders decided to end the episode and stop further slaughter by prosecuting, convicting, and executing a dozen Black residents. The trials quickly concluded. The NAACP hired a Little Rock Confederate war hero to handle the appeal, really. He lost and died shortly thereafter. Jones took over the case, sought federal habeas corpus, ultimately leading to U.S. Supreme Court involvement. Jones's habeas petition is a masterpiece of American legal writing, no fooling, a remarkable panorama of both legal and non-legal elements in the case. Holmes, writing for the court's majority, followed the Jones petition carefully, ruled in favor of the defendants, all 12 ultimately freed. Moore versus Dempsey. Shocked, the NAACP set up its legal defense fund. They didn't think they'd win. Charles Hamilton Houston, Thurgood Marshall, all the rest following. What changed? Read by itself, the Holmes opinion is tersely cryptic. Read against Holmes's earlier military meditations, mainly Soldier's Faith, his commencement address at Harvard in the 1890s, and his late Civil War diaries, we see Holmes recognizing the significance of Jones's counterframing, locating the marginalization of law within itself, marking the exercise of jurisdiction as itself an affirmative act, itself an ousting depiction, law's absence denied even in advance of its elaboration. Art, repeatable, the 14th Amendment reconceived as a series of engagements, not ratified, fought for and won across a judicial campaign. The question really is, what is this that I'm writing? It's not history. I move too much back and forth. Historians, professional historians don't do this. There's a lot of anthropology in this. Alfred Gell's book, Art and Agency, published in 1998, is an amazing book and a brilliant and a starting point for this. There's a lot of American studies in this. Soldier's Faith is just a central text in a lot of really interesting work. There's a lot of literary criticism floating around in here. And there's a lot of art history. I need to have things pop out, like literary, like real literarity, if that's a word, like real art, if that's a word. It's the popping out that solves the problem of banality. The popping out is art. In the end, that's what I'm trying to do with legal materials in this area. Try to do with crisis, try to do with really tough history. I'll stop.
Thank you, Patrick. I have next Lisa Iglesias.
Okay, thank you very much. You can all hear me? I'm
Yes.
delighted to be included. Thank you, Lily. And I also want to say that listening to my colleagues speak has been inspiring, and I've seen connections that I hadn't been aware of. So I'm going to associate my project with a fundamental reconsideration of the meaning of America, of our constitutional order of legality, as I see a lot of interconnections with the concerns that motivate Charlton's presentation and Pat's presentation. My interest is in law and philosophy, and specifically in political philosophy and ontology, which is the study of the nature of being. And I became interested and actually quite concerned with the question of the being of America. My concerns in this area go back to the shock of the torture scandal under the Bush administration. So I see the existential question of America being linked to that, although I would also associate it with the Reagan administration. At an ontological level, the question of being involves the question of identity and duration. So in order to think about the being of America, we need to think about how a thing comes to be itself and not something else, and how it sustains this distinction between what it is and everything it is not over time. So just focusing on the being of America in the era of Trump, in the context of this era, I've been particularly interested in exploring the nature of political violence and its implications for the constitutional order of legality, and the role of the Constitution in constituting and sustaining the being of America. And to put the question differently, the question is like, at what point and in what way and under what conditions does political violence constitute an existential threat to the being of a unity that we would agree and recognize as quote unquote America? This is a complicated area, and I cannot explain my position in 7 minutes. It's the subject of my dissertation, where I approach this question through the tradition of Western political philosophy and ontology, beginning with Plato. But here, what I want to do is focus on the way David Hume's philosophy can help us to think through the implications of political violence in the era of Trump. And in invoking Hume, I do not want to suggest that I'm unfamiliar with the fact that Hume shared much of the racial prejudices of his time. And I think that this is important in assessing the meaning and significance of his philosophical work. But there are 3 episodes of political violence in the era of Trump that provide an occasion to revisit Hume's philosophy. The first is May 25th, 2020, the public murder of George Floyd, an African-American man, by a white police officer that reactivated the Black Lives Matter movement as a rallying cry for protesters across the United States and beyond its border. The June 1st threat by President Trump to invoke the Insurrection Act of 1807 against Black Lives Matter, and the presidential incitement to insurrection of January 6th. So the question is whether these signs of these instances of political violence are signs of national disorder, perhaps impending disintegration. Are they an existential threat? And Hume's philosophy is relevant to this question because if we think about the being of America, which is the question at issue, as a system, in order to understand it as a system, we would understand that Hume's philosophy informs that system because it was invoked by the framers of the US Constitution as a point of reference for defending the design of the Constitution by reference to Hume's understanding of human nature. So Hume wrote a treatise on human nature, and concepts that I want to focus on specifically in that treatise that I think are relevant to the question of political violence and its existential implications is the structure of human passions as they interact dynamically with invented structures of social rank, and if we have time, with the concept of the liberty of indifference. Both of these are ways in which to understand how the being of America is existentially threatened at this moment. So with respect to the structure of passions, it's important to understand that he understood human nature as being, our relationship to each other is organized around passions. And passions are transmitted through the operation of sympathy, which means that generally speaking, we experience the pain and the joy of others through our imagination, and based on sympathy, their pain becomes our pain and their joy is our joy. And that's ordinarily how humans interact with each other. The problem is that our sympathy does not run to all humanity in the same way or to the same degree. So solidarity depends upon, and the running of our sympathy depends in part on our understanding of sameness and difference. So to the extent that others are viewed as the same as us, we tend to have that structure of sympathy, and it becomes more attenuated the more different they are. So he gives this very famous example of a European in China, an Englishman in Italy, or a person on the moon, in each instance suggesting, for example, that in a foreign country, a common national identity is sufficient sameness for solidarity, whereas in our own country, national identity is insufficient to overcome hierarchies of difference organized in different societies in different ways. In his, it would be the servant versus master, the prince versus subject. In ours, organized around race, class, national origin. So the problem is that we engage these differences and respond to our perceptions of other people's experiences depending upon how we view their experiences affecting our position in these invented social hierarchies. Now, if you applied that to the Black Lives Matter protest, while a common humanity explains why many of us have sympathy for the suffering of George Floyd and his family and his friends, there are many of those who see their social rank threatened by the demands to eliminate the structures that enforce Black subordination. So this would include people who are vested in a rank order that they enjoy as a result of the institution of policing, or by virtue of white privilege that is the other side of Black subordination. So the question then is these differential patterns of sympathy organized around sameness of difference an existential threat to America? And the really quick answer is no, unless the differentiation, it becomes solidified in two opposed totalizing factions. And I believe that Trump's effort to generate a race war is pointing in that direction, but I have other things to say about why it is and how it is that we would respond to the existential threat. And I'm out of time, but that would be where I would stop now.
Thank you very much, Lisa. Next, I would love to hear from Shara.
Hi, everyone. Everyone can hear me? Awesome. Okay, I'm going to share my screen. So it is absolutely incredible to be a part of this distinguished group, and hearing what you all are doing makes me not only want to do more, but figure out ways that we can collaborate and continue to work together and grow our projects. So my project is focused on criminal justice reform through education. And as everybody knows, I teach legal research and writing, but my true passion, in addition to that, remains with criminal justice. I started my career as a public defender, and my heart still very much remains in that. And so in looking at where we are, especially in Florida, we live in, well, I don't need to talk about Florida. We all know about Florida, but the numbers show that Miami-Dade County has one of the highest incarceration rates in the nation. And that being said, 22,000 people are released annually back into our communities. But our prison system currently does very little, if not nothing at all, to actually educate and care for our incarcerated population. So the numbers to me are staggering. We're looking at almost $23,000 a year is what it costs to house one individual. And $1 of that is allocated to education. What that means is that next to no classes are offered by the Department of Corrections at Dade Correctional Institution, where I teach. And that is in spite of what the research shows. So we know that individuals who participate in any sort of educational programming while they are incarcerated have 43% less chance of recidivating than incarcerated individuals who do not. They are at a 75% less chance of having infractions while they are incarcerated. And so when we look at this just through a dollars and cents process, we recognize that correctional education is cost effective because it saves up to $5 on a 3-year reincarceration cost. That being said, what can we do, right? So all of this, we know that education impacts and amplifies the voice of the incarcerated, but there's little opportunity for them to utilize education and to become educated while they're in prison. So about three years ago, in collaboration with HOPE at the law school and Exchange for Change, which is a nonprofit organization that brings education on a volunteer basis inside the prisons, I was asked to go teach a 2-hour class on legal writing to a group of incarcerated students down at Dade Correctional. I went down with probably about 15 outside law students and not really knowing what to expect. Our class that day was comprised of the law clerks inside the institution. And in 2 hours, I did essentially a boot camp of legal writing, persuasion, and analysis, and left. And within 2 weeks, Marnie called me and said, they want more, they want a semester. And so that's what we delivered. Over the course of 4 semesters prior to COVID, I taught legal research and writing, legal persuasive, motion writing, culminating in oral argument to incarcerated individuals. I think I probably graduated over 60 students from Dade Correctional who took our class. They wrote motions, they argued persuasive oral arguments in the same way that every first-year law student does around the entire country. We developed a case file, and essentially what happened is the outside students, so our own law students, go in, collaborate, and work together in pairs with incarcerated individuals to develop the legal research and writing skills. And because this was done every other week, on the off weeks when we weren't there, the incarcerated students worked with each other to do their research, to write the argument, and essentially what we were doing down there became institutionalized. There were so many students that on the compound, there were students who had finished our class, graduated from our class, and were willing to help others through the process of legal writing. Obviously, COVID happened and we were stopped entirely. Everything came to a halt. I was able to Zoom with our inside students once since this occurred, but we didn't. I felt the need that I couldn't just stop entirely. We took on the role of this connection and this humanistic connection, as well as also empowering and amplifying their voices. And so we created News for You, which essentially is a newsletter that our outside students, our law students, lawyers from the community, individuals contribute to, and then it goes inside. And in return, our inside students were sending us a newsletter filled with their information, filled with their stories, filled with their voices, in a way to continue sort of this connection and make them realize that we want to remain connected. We know that education is one step one very small step, but yet a very important step in our efforts to change the system, to fight for change, to fight for education being a right, not a privilege, not just for incarcerated individuals. And so that's what I do. I'm looking to grow the program. My students on the inside want advanced legal writing. They want as many programs as we are willing to offer. And I'm willing to do it as soon as we can get back inside. Thank you.
Hi there. It's lovely to follow Shara. I will just say that she's a prime example of why these conversations are so phenomenal. When we had visited down at Dade Correctional over approximately 6 months, listening and learning about the needs of the incarcerated individuals, and when they mentioned legal research and writing, I reached out to Robin Shard, and she graciously, one of our librarians, and she graciously came down. And then as soon as we saw the interest and capacity for the course to evolve, I reached out to Shara, and as you heard, she took the ball and has transformed lives inside and out ever since. So I just want to thank her, and it's a pleasure to follow her so I can celebrate her unyielding efforts. I'm going to share a PowerPoint. Can we see it? A thumbs up? Yes, we're good. Okay, super. So I wear a couple of hats, as Dean Levy shared. A proud graduate, a lecturer of law, and founder and director of Hope Public Interest Resource Center. So I connect with students in and out of the classroom in different modalities, advising, teaching, designing projects. We work to promote engagement, conscientious commitment to working to combat injustice, and to address systemic barriers through education, program, and initiative. So I'm first going to share a couple of things about the center just to lay the context, and then a few sample projects. So, all right. So the Resource Center is open to all students. It's our mission that all of our students appreciate the privilege of a legal education, and that in doing so, the obligation and capacity to deliver justice and to give back regardless of the pathway they pursue in their careers. Our way of engaging and activating them through opportunities plants the seed that we hope they will carry throughout their careers. How do we do that? We're working in partnership with agencies and communities, with private sector entities on advocacy and pro bono efforts, and I'll share a few of those examples. From a mission standpoint and a student engagement and cultivation standpoint, we want to make sure that our students have the ability, wherever they are in the continuum of their experiences, to understand concepts of social justice advocacy and the urgency for their participation in the delivery of justice by helping them to understand different theories of change, different models of lawyering, understanding the various points of entry through which they can contribute meaningful delivery of services. Excuse me. In doing so, they are acquiring transferable skills. And so that pro bono ethic is at the core of developing the problem solving, understanding communities, understanding the history and the context and lens through which these systems have evolved, and helping them to develop their lawyering identity. It's also about creating community, helping those students who have areas of interest and pathways to connect to each other and to connect to our incredibly supportive and extensive alumni network. Hope is home to a number of programs. Miami Scholars Program is our flagship program for a 3-year scholarship for students with exceptional academic records and a demonstrated commitment to public interest. In addition, we feature a social justice series, which are designed to be small group opportunities for our students to interact with practitioners and understand social justice advocacy from various vantage points and fields. They're small group by design to allow students to listen and ask questions, to probe, to assign meaning, to challenge, to hear, and really contemplate the difficult themes that they're being exposed to. There's no presumption that they are already at a point of understanding. There's the humility of accepting that we only understand our own walk, and to really become effective advocates, we need to engage in open environments around critical issues of social justice. It also leads to mentoring opportunities, broadening the network of individuals actively and authentically promoting social justice, and builds relationship with community agencies, leveraging the resources we have as a phenomenal institution with this kind of commitment to support the much needed work locally, nationally, and internationally. in helping our students to evolve and train, we want them to avail themselves of opportunities in agencies near and far. We have 2 fellowship programs, Hope Fellows and SPIF. SPIF are for our rising 2Ls, and the students engage in a social justice lawyering course over the summer while they do their full-time placement, and our Hope Fellows work nationally and internationally and engage in journal writing and reflection and a webinar series with our 3 staff attorneys from the Hope office. In addition, we feature alternative breaks, typically winter and spring, but this year winter, we had 7 weeks. We had 7 projects with over 30 students participating, and I'll shine a light on a few of those in a moment. We challenge all of our students to meet a pro bono challenge and a community challenge, and in doing so, again, furthering that ethic, saying it's our responsibility, let's create the opportunities for you so that you can understand the context of delivering justice, but let's do so in a way that speaks to the variety of goals and pathways that you have. And so you'll see the project list and how that reflects that. We also have ongoing pro bono projects. Those are designed in partnership with agencies. So sometimes a student comes in and they say, before law school, I worked with this community, I worked on this issue. This is a part of me and my story, and I want to continue in an advocacy capacity. And we build projects. Most often, an agency reaches out to the Hope Public Interest Resource Center and says, we understand that you're engaged in, and how can we collaborate, because we do not have the capacity right now to address these pressing issues. What can we do? My colleague Sarah Baez is a phenomenal asset in the development of those pro bono projects, identifying the scope of the project, thinking about the nature and the need, the skills that are required, and defining that in a way to engage students, sometime in short-term projects, discrete projects and research, other times in ongoing projects, and creating training that engages the lawyers from the agency with our students to ensure that the capacity is there, substantive learning happens, the how-to and problem solving is addressed. So I mentioned our challenges. We obviously want to, as I mentioned, cultivate that pro bono ethic in all of our students. And so we structure challenges. Projects range all over, some students engaging, lots of time. Okay, I'm gonna move quickly, I'm gonna skip. It goes quickly, I'm gonna tell you 3 projects. Getting our students involved. One project this year, 1619, is a collaborative approach with the Pulitzer Center, Howard Law School, in delivering and delivering curriculum to augment the K through 12 curriculum to ensure that law schools are teaching and addressing critical issues in a lens through racial justice and social justice. Our students have partnered. There have been 3 webinars. Tomorrow is the one with Nicole Hannah-Jones, and our students have performed beautifully. Looking at some of the projects, you see the various areas of advocacy that have been touched upon through our remote alternative breaks recently. And the last project I want to signal is a partnership with the ABA, where our students are really learning critical research analysis, data synthesis skills, cataloging legislation across 50 states, and thinking about strategies to ensure, through my teaching theory and ADR design system, how to diagnose the problem, map resources, understand interests, and then devise solutions and propose them with an eye towards the feasibility for the implementation to change the issue where the barrier exists, evaluate, and then redesign in partnership with community. So you can see there are a variety of projects and ways in which we're training to complement and engage our students, taking their substantive learning and activating them to the next steps in partnership with community. Thank you very much.
Perfect, Marnie. Thank you for all the work you do with our wonderful students. And then the work that they pass on, of course. So next, I would have Jonelle Newman and Melissa Swain together, but unfortunately they have class, and so they are unable to meet with us in person. So they have done a video, and which Hakeem will share right now.
Greetings, everyone. I'm Jonelle Newman from the Health Rights Clinic at the law school, and I'm here with Melissa. We're sorry we aren't here live, but we had another clinic obligation today.
And so we just wanted to start out by giving you guys a little bit of background and historical perspective of the Health Rights Clinic. So the Health Rights Clinic has been a medical legal partnership with the Miller School of Medicine since 2005. And we have multiple community and medical partnerships that I will share with you in the next couple of slides. Part of the community impact that we've made is that we have represented over 3,500 low-income patients in the Miami area in cases including public benefits, Social Security, disability cases, many immigration cases, health insurance, Medicaid, Medicare, and also veterans benefits. And we have, as part of the University of Miami, recovered over $17.3 million. And we've trained over 320 future lawyers in this type of law. And so in terms of our community health and medical partners, the University of Miami Comprehensive AIDS Program is our first medical partnership. And I would say this is the quote unquote meat and potatoes of our clinic. This is where the majority of our clients and their patients come from. We also have a newer partnership with the University of Miami Sylvester Comprehensive Cancer Center. And these are cases where we really have to move quickly to get people the benefits that they're entitled to. We've also worked extensively with the Batchelor Children's Research Institute, as well as Mailman Center for Child Development. We had a very extensive partnership with Jefferson Reeves Senior Health Center underneath the Overtown Bridge of 95, where we really got interesting patient cases all over the board. Anything you could think of in terms of patient medical treatment and care came out of Jefferson Reeves, and we were able to help those patients in their legal matters. A very interesting partnership with the Pediatric Mobile Clinic, where law students, really got a chance to get on a mobile clinic onto the bus, helping multiple young individuals in need of legal assistance. And one of our most rewarding, I would say, medical partnerships and community partnerships was with Miami veterans, serving them in any legal need that we could.
So in terms of who we represent demographically in our community, you can see that we're not quite, but very close to evenly divided in terms of Latino and Black clients. And as you can see from our language slide, I see that the race, ethnicity, and primary language are flipped, but most of our clients don't speak English. Only 18% are really fluent in English. We have a very large Haitian Creole speaking client population, as well as Spanish population. We often tell our students that our clinic serves as a language immersion program. This is a very interesting development for us. We have, since our inception, struggled to meet the legal needs of the communities that we serve. When we started the clinic, and for a lot longer than that, more than half of our docket was Social Security, disability, and public benefits. Then we had a smattering of other cases. And then about a third of our cases were immigration, because in fact, if you can't adjust your immigration status, then you don't get access to life-sustaining public benefits. And that's a real reflection of who's poor in our community and who needs help. So our clients need to adjust their immigration status, because if they don't, they will never be able to receive the benefits that they need. Because there are there's a huge community lack of people to do immigration cases, we have stepped into the breach. But in the last 4-5 years, we have seen our immigration caseload skyrocket and really start to take over our docket. We are hopeful with some more humane immigration policies coming online, immigration will no longer have such a stranglehold over the cases that we're able to do. We also have, although we primarily represent individuals with their own legal claims, our clinic also has a very strong history, again, in responding to the needs of our community. And the needs of our community sometimes require that we take on bigger scale impact advocacy. We have taken on the state of Florida at least twice in an impact advocacy way. We did a class action lawsuit, a statewide class action against the state of Florida and the federal government for discrimination against people with disabilities in disaster relief food stamps. If you look down at the bottom of the page, that's a picture of days and days, 24-hour days, that people had to line up to get food after Hurricane Irma. And if you were disabled and not able to do that, then you couldn't get food. We were able to resolve that. We were also able to resolve the need of persons who have dialysis to receive emergency Medicaid if they couldn't get Medicare or Medicaid because of their immigration status. We did a large impact advocacy piece to get the Haitian community in Miami registered for temporary protected status after the earthquake in 2010. And we responded to those children's needs that you saw in the pediatric mobile clinic by taking on a number of special immigrant juvenile cases and advocacy with the state on that. We've also sued the Social Security Administration when their delays in hearing our clients' disability cases became unreasonable. Those are just some of the impact advocacy issues that the clinic also has taken on. And here's the money slide. You can see just in the last year that over $364,000 has come into the community as a result of our Social Security disability work. Our students have even during the COVID shutdown, conducted 8 Social Security disability hearings before federal administrative law judges. We've also brought in thousands of dollars in food stamps, but I always like to talk about the value, even though we don't quantify it, of Medicaid, Medicare, people on insurance. 6 people became naturalized US citizens during this very difficult period of time. We've appeared before immigration 10 times and have 15 different documentation approvals. So again, our community impact, we think, goes beyond the numbers, even though we think the numbers are pretty impressive.
And so just to sum up, and what we really want to emphasize is the impact over a 15 going on 16 year time frame that the Health Rights Clinic, coming out of the University of Miami in partnership with the Miller School of Medicine, has won over $17.3 million in benefits, naturalized or helped clients become US citizens, 213, 47 lawful permanent residents, over 3,500 clients served, 227 food stamp cases, 476 Social Security cases, and on and on. And one of the most striking numbers is that we have had law students complete over 225,000 legal services pro bono hours representing the Miami's most vulnerable patient clients. Thank you very much.
Thanks for letting us talk to you today.
Didn't I say our clinics are incredibly impactful? So here's another impactful clinic, the Immigration Clinic with Rebecca Sharpless. Take it away.
Thank you. Thank you, Lily. And thank you, Hakeem, for organizing this. And thank you, Jonelle and Melissa, for everything that you do. I kind of want to take your clinic. So I teach the Immigration Clinic, but today I'm actually going to share a project that I'm working on and not talk about the clinic so much, although the clinic is certainly informed by my scholarship, and certainly this current project has been informed by the clinic work. So as Lily mentioned, I work at the intersection of immigration enforcement and the criminal justice systems. Crimmigration is what Donna called it, and I think that's right? So we're worried about people who are both in the middle of an immigration enforcement action and may have also been in the criminal justice system. And in particular, I try to bring in my scholarship a critical lens to the idea of the good immigrant. There's this narrative in traditional immigration reform that has the trope, immigrants are not criminals. And so I sort of take a critical approach to recognizing the limitations of that narrative because it erases incarcerated non-citizens. And there's this growing awareness, I think, generally in our nation about police brutality and mass incarceration in the criminal justice system, but we're seeing less of a focus in our immigration enforcement system, which is just as vast and just as dehumanizing. But the project that actually I want to talk about has nothing to do with the law review article and has everything to do with writing a book, but not a traditional legal book, but rather a narrative nonfiction book. And this is a stretch for me. I'm taking a page from those amongst us who are creative writers, who I've never been a creative writer, but I'm taking a page from them to say that I'm going to, in this book, show rather than tell. I think my law review articles are generally telling people or analyzing things. And this book is about telling the story or various strands of a story relating to an experience that the clinic was involved in when 92 Somali men and women were shackled at their wrists, waists, and legs and held for 2 days on a failed deportation flight, during which they also were abused by special ops immigration officers on the flight. The flight eventually returned to the United States, could not complete its deportation journey, and our clinic and others got involved in some legal battles for the entire group, but also for each individual that was on the flight. So the book is called Shackled. And we learned about what happened when Newsweek interviewed one of the gentlemen who was on the plane, and he likened it to a slave ship, which is maybe an extreme analogy, but he felt appropriate. Again, people were kept for 2 days, immobilized on a plane in shackles. And you can see, here's a visual of the shackles that ICE uses routinely on these charter flights to bind the wrists, the waists, and legs of people. Here's a close-up. And on the flight, they actually deployed straitjackets like this against individuals who stood up. The bathrooms also weren't working during the flight, and people were protesting, saying, we need to stand up, we need to get off the plane, we need to walk around. And when people did that, they were not only beaten, but they were tied up in straitjackets. So the book interweaves the stories of two protagonists. It is not a book about lawyers. It is not a lawyers as heroes narrative. It is written from the perspective of two brave protagonists, two men who are on the flight. And the story is about not only what happened on the flight, but it goes into their history in Somalia, particularly the Civil War and the time period in Somalia after that. It also moves forward through their legal cases, their individual legal cases, through their detention and what happens in detention in the United States. Some of them were detained for very long periods of time upon return to the United States. And then there's also a research thread where I am giving the reader a sense of the vast apparatus of our deportation machine here in the United States. But the intent is for it to be a story that reads like a novel, does not read like a piece of legal writing, but reads like a novel, and time will tell whether I will accomplish that. But I wanted to show you just, and I can end with just a few more shots. One of the protagonists is Saeed Janale. This is a picture of him when I brought, with Dr. Symes from the medical school, and I and some other attorneys went to visit some of the detained gentlemen at Glades Detention Center, which is about 2.5 hours away. Dr. Symes and a couple of his colleagues came over to examine the men who were injured on the flight, and we were allowed to meet with Saeed. But because he had been in solitary confinement and had been pepper sprayed and then put in solitary confinement, he was brought to us in shackles, in precisely the same shackles that he was wearing when he was on the flight to Somalia. So this is a picture of him. They would not take off the shackles for the medical exam or the legal interview. So he had to sit here in shackles while we talked with him. So this was his reality, both on the flight and then at the detention center back here in Florida. And I'll just end though with a happy note. He, in contrast to the other protagonists, his case is actually won in immigration court at the end of the day. So he went from someone who was on the cusp of being back in Somalia, separated from his US citizen wife and children, to being outside in the United States, now living, and here's his injury, now living with his family outside of Boston. And over the summer, when I reconnected with him to interview him for the book, outside in a COVID safe environment, this is him with 2 of his kids. Thank you.
Thank you very much, Becky. Next, I have Keely Stewart.
Thank you, Lily, and thank you to Erin and the ULINK team. I'm enjoying so much hearing about the work of my colleagues. So I am yet another clinician here at Miami Law. I co-teach the Children and Youth Law Clinic with Bernie Perlmutter and Robert Latham. And along with our law students, we represent children in the foster care system. We handle civil juvenile court cases that happen when a caregiver is alleged to have abused or abandoned or neglected their child. And we also work on other types of cases to help our child clients get much needed medical services or educational services, etc. For a little bit of context, for those of you who are unfamiliar, there's tremendous inequity in the child welfare system. Nationally, Black and Native American children are overrepresented. And even though Latinx children are underrepresented nationally, they are overrepresented in certain geographic locations. LGBTQ youth and children with disabilities are also overrepresented in care. And it's important to note that the child welfare system primarily targets poor families. Over 60% of the cases are for neglect, which is defined under state law in ways that give state agencies a lot of discretion to intervene in situations that correlate with poverty. So to make that a little bit more concrete, here in Miami, the 3 zip codes with the highest rates of removing children from their families and placing them in foster care are in 3 poor, predominantly Black neighborhoods. So it's the area they're zip codes, so they run through different neighborhoods, but it's essentially Allapattah, Brownsville, West Little River are two of the zip codes. And then there's a third zip code in Miami Gardens, the sort of most western edge of Miami Gardens. And so today I wanted to tell you about two interdisciplinary projects that are aimed at improving outcomes for children and families. Once children are actually in the foster care system, studies show that outcomes on a host of well-being indicators are very poor and are often worse for children of color. So the first project that I'm involved in is First Star at Academy. It's a collaborative initiative between the clinic, the School of Education and Human Development, and a national nonprofit called First Star. We offer a holistic 4-year college prep program for high school students in foster care. And the model is that we work with the same cohort of students from 9th to 12th grade. We started in 2017, so my first cohort of babies are actually in 12th grade right now and graduating high school at the end of this academic year. Every summer, the students live in the dorms on campus, at least pre-COVID, and they attend academic classes and enrichment activities. The program provides all sorts of both educational advocacy and other types of advocacy to all of the students, but then the students with the more intensive legal needs are referred to our clinic for representation. And so the concept is really simple, right? The program serves as the village that supports students during high school. But the brilliant thing about the model is that it's situated within a university that then makes all of the university's access resources accessible to students and puts students in a university setting so that they can start seeing themselves there. So for example, our First Star students have participated in pipeline programs at the law school last summer that was organized by my colleague, Charlton Copeland, and at pipeline programs in the School of School of Architecture. We are currently partnering with the ULINK team led by Drs. Agrawal and Dykstra that developed JANUS, which stands for Joint Academic Nurtureship of Underrepresented Students. It's a program to provide mentorship and research experience in STEAM fields to Black undergrad students. So those undergrad students here at are then partnered with our First Star students to be mentors and to help get our First Star students some research and lab exposure as well. First Star also has an evaluation and an empirical research component. And along with my co-PI in the School of Ed, Wendy Cavendish, we're evaluating the effectiveness of the program as an intervention for at-risk youth. We're using both quantitative and qualitative measures that try to account for all of the complicated system interactions as well as intersectional identities. And one of the key things is that we center youth voices through focus groups that we do very regularly. And we use this evaluation not only as for sort of feedback on the outcomes, but also as part of an iterative theory of change process. So we're constantly doing system improvement. The other project that I wanted to talk to you about is sort of a larger community impact project that tries to improve the foster care system through a racial justice lens. It's a collective impact project with many of the other key stakeholders in Miami's child welfare system. And the overarching goal of the project is to really strengthen community resources so that we reduce the need for children to even enter the foster care system in the first place. We're going to initially focus on those 3 communities that I mentioned with the really high removal rates. And so our contribution to this larger impact collaborative will be to analyze data to better understand the reason kids are coming into the system, do an environmental assessment to figure out strengths and gaps in services in those communities, do some policy analysis to identify policies that contribute to disproportionality or might be barriers to prevention work, and then ultimately do some advocacy to try to address whatever we learn are sort of the biggest driving factors. And we also want to create some very user-friendly educational and policy material so that decision makers, people who are impacted by inequity, and others can have some good information to better be able to engage in this type of advocacy. It's an interdisciplinary project. So far we're collaborating with Scott Evans and one of his PhD students, Tamara Greek, in the School of Education. And then I'm in conversations with Tatiana Perino and Viviana Horrigan in Public Health. And so hopefully their master's students will be pairing up with some of our law students in the fall. And so, of course, my scholarship theorizes about all of this work in many different ways. Thank you.
Thank you, Keely. So last but not to the only, this is not the only group of students, of faculty who deal with our students and address these important issues, just the people that I could stick into an hour and a half. And so next and last, we have Bill Wyden.
Thank you, Lily. What I'm going to do today is describe to you a project that I'm working on relating to educating law students about issues of racial justice and how one might do that early in law school, maybe even during the first few weeks. What I'm going to talk about is an essay that was published last Friday, entitled Jamestown 1619 and the Common Law. And I'm going to share a little bit about that essay with you. You can find it on Jurist, and there's also a version for those that want research backup, a version posted with footnotes. So the 1619 project focused on the year in which enslaved Africans were brought to the New World for the first time. And what this did is focus people on a part of our history that is often subject to what I would call erasure. We didn't like to talk about some of the negative aspects of our history or the failures. And so I decided, well, what else was going on in 1619 that might be of particular interest from a legal perspective? And something else important happened in 1619 that most people don't know about. In 1619, the gentleman, Sir George Yeardley, who was running Jamestown, abandoned something called Dale's Code and reinstated the common law to govern the Jamestown colony in April. The enslaved Africans were brought in August. And in fact, George Yeardley actually probably, we think, purchased some of those first enslaved Africans. And so what this creates is a circumstance in which implicitly the common law, at least as interpreted by the people in Jamestown, sanctioned the institution of slavery. And so the question arises both for students, well, what is the common law? Well, this massive failure of the common law and its interpretation is a chance to teach students what the common law is. And that's one of its, I think, benefits. But we have to ask, why did the common law fail to address the issue of slavery? Was that something that's a problem with the common law, or was this just a problem of its administration? And so that's one thing that I would like to encourage students to look at. Now, importantly, Virginia, among all of the colonies, was founded primarily for profit. Okay, it was initially not a territory, as it were, of the UK, or not administered as such. It was administered as a corporation for profit. There's a lot of reasons why the Virginia Company of London had trouble, and in about 1624, they dissolved the Virginia Company and it actually became part of England. But as we take a look then of what happened in Virginia, what we see is an evolution. Virginia experienced chronic labor shortages. And what they traditionally did early on was use white indentured servants, which were servants for a term of years for a particular period of time, right? Now, although this was the preferred approach until close to 1700, they supplemented the labor of the indentured servants by bringing in enslaved Africans. And so that was how they operated. Now, there were a number of reasons why this might have happened, including the high mortality rate of everybody in Virginia at the time. Initially, it was cheaper to buy someone for a term of years than for their natural life. But over time, that started to change, right? And then once people were able to acclimate and maybe they had tamed the wilderness a little better, people started to survive. And then it became more economic to own a person than to own a number of years from a person. And so what we find is that the institution of slavery provided three distinct economic benefits to the aristocracy in Virginia. First, as longevity increased, the profits increased for those employing slave labor. Second, there was a side product that most people don't focus on, which is the enslaved labor force actually protected the large land holdings from the political demands of the free persons who completed servitude, because an enslaved population never enters the labor market. And so what this meant was the existing landed holders did not have to compete with the newly freed indentured servants for them to add to their estate, right? And the third thing was that Dale's Code, which was essentially a form of martial law, had no jury system. And so once you changed to government under the common law, an indentured servant could more effectively litigate the details of an indenture contract, and that raised the transaction costs. And so there were all of these motives that were pushing people towards slavery. A big problem existed, though, for this horrible institution, and that was that how you could motivate an indentured servant by having penalties, which would extend the term of their servitude. But how do you motivate an enslaved person to work? The solution was to use terror and violence in order to motivate people. And so this is the story that I basically tell in this essay, which you can find on Jurists. One detail, finally, much later in the history of the common law, Lord Mansfield finally declared that slavery was odious and not supported by the common law. That happened in 1772. But when Virginia received the common law, they didn't in 1776, they did it as of 1607, so that in fact you didn't have to worry about the precedent that was created by Lord Mansfield. This and a number of other terrible things of history are described in this essay, which I would hope students to use for teaching as a first exposure to the common law and how the common law sometimes gets changed by statutes. Thank you, Lily.
Thank you very much, Bill. So we have heard from my wonderful colleagues, both abstract and concrete descriptions of their important work relating to racial and social justice, to the protection of the most vulnerable among us, and to the need for us to confront climate and ensure climate justice. We've heard many sobering things, but our colleagues also serve, I think, as object lessons for hope. We've seen their passion and their engagement and that of our students whom they guide. They serve as examples that demonstrate the role of law and lawyers as self-conscious wielders of power for good. This school's roots are in what legal academics call law and society. We see law as deeply rooted in society and its woes, and we also see a role for law and lawyers and legal theorists to help in that project, which is why we are part of One U, and how we appreciate the opportunity given to us by Erin to show how we fit into the important work of social justice that we associate with this university. Now, of course, I'm thrilled that we've been able to offer you 12 professor presentations, but that unfortunately means that we have about 2 minutes rather for Q&A. So I have a couple of questions in the queue, which I will read, but everyone in the audience is invited, please, to feel free to reach out to our inspiring speakers for continued conversation and collaboration. So my first question is from Nabil Hussein, who says, hello, everyone. Are there Law faculty considering ways in which we can prosecute, quote, ghost candidates and their co-conspirators in Florida? More importantly, he asks, barring people and organizations from succeeding in affecting the outcome of elections again. In the last election, there were a number of stunning Democratic losses due to Republican PACs that created, quote, liberal ghost candidates that deceitfully siphoned votes. The next question I have is from Madeline Placencia, who asks, I would love to hear the presenters' thoughts on the following question. When do the presenters think was the turning point in American politics for the current polarization of the Republican Party, specifically related to the current white supremacist racial agenda Professor Copeland referenced? And finally, I have a nice comment. This was truly amazing. I can't wait to follow along with these projects. Thank you to everyone for this insightful presentation. So, oh darn, it's 2. That means I need to close, but at least I've articulated the questions. All of you are available with your addresses on the webpage. So I invite everyone to continue the conversation. Thank you for coming.